Legal dictation, exercise 78, start. It is not disputed that the accused-appellant Ram Dulare is a handicapped person, who has filed his disability certificate issued by Medical Board of Chief Medical Officer, menu certifying 60% disability in his right leg, and it has been admitted by PW2 and PW3 that accused-appellant is a handicapped person disabled with one leg and cannot walk properly because of problem with one leg. Full stop. It is not the case of the prosecution that the accused-appellant was having love affair with the victim, the minor girl, and enticed her away on account of the love affair. Full stop. He is also pertinent to mention that since the accused-appellant is a handicapped person until and otherwise proved, no girl is supposed to fall in love with such a disabled person, and so even in case of any one side liking of victim by accused-appellant, there can be no reason for the victim to go with the accused-appellant at her own. Full stop. There is no whisper of any force having been used by the accused-appellant or other accused persons in forcibly setting the victim in jeep with the accused-appellant. Full stop. It has been contended by the accused-appellant that the victim was major and was living with her parents in Jaunpur, and the police have not made any efforts to trace out the victim at Jaunpur or anywhere else, where the appellant allegedly taken her away. Full stop. It is pertinent to mention that the first informant is a law graduate, and it is expected from him as a prudent man to inform the police immediately after the incident, so that there could have been better possibility of tracing out the victim. Full stop. The prosecution has also not made any efforts of tracing the victim by taking the accused-appellant on police remand. Full stop. The prosecution has failed to explain the inordinate delay of around 4 days in lodging FIR. Full stop. It has also been contended that as per entries in the family register, the victim was major at the time of incident. Full stop. The possibility of eloping of victim in the darkness of night without knowledge of anybody, may not be ruled out. Full stop. Para. Admittedly, the first informant PW3 is execu- highly educated person and postgraduate, as has been admitted by him in his cross-examination at page 8 of his cross-examination that he is MA, LLB, full stop. He has stated that he lives at home and does agricultural work, and since the matter was related to his prestige, he was very nervous, and so instead of writing the written report himself, got it written by Harish Yadav on his dictation, and in dictating there was no problem, full stop. It is pertinent to mention that the father of the victim had come the very next day, but no reason has been assigned as to why the FIR was not loading by father himself, full stop. PW1 and PW2 are only chance witnesses and have also stated to have inquired into with co-accused as to where the victim and accused-appellant have gone, what even when no reply was given by them, they did not inform the first informant or father of the victim, full stop, para. Similarly, on alleged asking by PW1 and PW2 from Ram Manohar and others, not giving any threat by them is quite unnatural, while on mere inquiry by the first informant, they allegedly threatened him, full stop. The first informant was not assigned any reason when neither he was eyewitnesses of the occurrence nor got any information from alleged eyewitnesses, then why and on what ground he approached the family members of accused/appellant, that is, co-accused persons, therefore inquiring about the victim, full stop. It is settled principle of law that the evidence of interest or related witnesses should be considered with caution, and until and unless it is found to be trustworthy, the conviction of accused on the basis of evidence of related or interested witnesses is not justified, full stop. In view of the discussions made above and considering the unnatural conduct of PW1 and PW2, I am of the considered view that they are not proved to be eyewitnesses of the incident of enticing away victim by accused/appellant in presence of co-accused persons or otherwise, and their testimony is neither reliable nor trustworthy, full stop.